21 years. Over 2 decades of showing up, delivering results, building a career inside one company. And then one day you're called into a room, your laptop is taken from your hands, and you're told you're done. No real explanation, no transition plan, no severance. And oh, by the way, you can't work for a competitor for the next 6 months either. That's not a hypothetical. That happened to a real person just a week and a half ago in Chicago. And the question they're now asking is one that should make every working American stop and think, is any of this even legal? Let's set the scene properly, because the details here matter enormously. This person spent 21 years working for a large national media company. That's not a short stint. That's not someone who jumped ship after 2 years looking for a better offer. That's someone who gave the better part of their adult working life to one organization. They built expertise, relationships, and an entire professional identity inside a single industry. They have 3 kids depending on them. And in the span of what sounds like a 15-minute meeting, all of that was swept off the table. Now here's where it gets legally interesting and genuinely alarming. When they followed up with HR after the layoff, they learned 2 critical things. First, there would be no severance payment of any kind. Second, they are bound by a non-compete agreement that restricts them from working for a competitor for 6 months. Think about what that combination actually means in practice. You have no income coming in, and you are legally restricted from pursuing the most obvious jobs you'd be qualified for. Jobs in the same industry where you spent 2 decades developing specialized skills. You are essentially being held in professional limbo with no financial parachute to survive that limbo. For someone supporting 3 children, this isn't just stressful, it's a genuine crisis. And the legal questions sitting underneath all of this are ones that employment attorneys deal with regularly, but that most everyday workers have never had to think about until a moment exactly like this one hits them out of nowhere. So let's walk through what actually happened here, what the law says about it, and what options this person, and anyone in a similar situation, actually has. The layoff itself was part of what the company called a mass layoff. That phrase carries specific legal weight. In the United States, there's a federal law called the WARN Act, the Worker Adjustment and Retraining Notification Act. Under federal WARN, if a company with 100 or more employees is laying off a significant number of workers, they are required to provide 60 days of advance written notice. If they failed to do that here, and based on this account, it sounds like there was 0 advance notice, the company may have violated federal law. And that matters because WARN Act violations can entitle workers to back pay and benefits for the period of the violation. Illinois also has its own state-level protections that can sometimes extend these rights further. Now let's talk about the non-compete, because this is where things get particularly fascinating from a legal standpoint. Non-compete agreements have been a standard tool in corporate America for decades. Companies use them to prevent employees from leaving and immediately going to work for a direct rival, taking trade secrets, client relationships, or institutional knowledge with them. That's the legitimate business rationale. But courts across the country have increasingly scrutinized whether non-competes are actually enforceable, and Illinois has been at the forefront of that shift. In 2022, Illinois passed significant reforms to its non-compete law. Under the Illinois Freedom to Work Act as amended, non-compete agreements are only enforceable if certain conditions are met. One of the most important conditions is consideration, meaning the employee has to receive something of value in exchange for agreeing to the restriction. The law specifically states that adequate consideration can include a period of employment of at least 2 years after the agreement is signed, or some other form of legitimate benefit. But here's the critical issue in this situation. This person was laid off. They didn't leave voluntarily. They didn't breach their contract. They were terminated as part of a mass layoff. And they are receiving 0 severance, 0 compensation tied to the non-compete restriction. Nothing. Illinois courts have actually addressed situations like this. When an employee is laid off, especially without cause, and receives no severance or other compensation in connection with the non-compete, courts have found that enforcing the non-compete can be unconscionable. There's a basic fairness doctrine embedded in contract law. You can't hold someone to a restriction that benefits only you, especially when you've given them nothing in return and you've been the one to end the employment relationship. Now, does that mean the non-compete is automatically unenforceable? Not necessarily. It means there's a genuine, substantive legal argument to be made. And in Illinois, right now, given the direction the courts and the legislature have been moving on this issue, that argument has real teeth. There's also the question of the non-compete scope. 6 months is on the shorter end of what companies typically try to enforce. But the question isn't just duration, it's also geographic scope. What industries or roles are restricted, and how broadly the term competitor is defined. If the agreement was written in overly broad terms, which many corporate non-competes are because they're often drafted to be maximally restrictive, that's another avenue for challenge. Now let's address the question that this person asks directly. Is it even worth pursuing an employment lawyer? Or will a massive corporation just drag things out until it's not worth fighting? This is a fear that stops a lot of people from ever picking up the phone. And it's understandable. The imagery of going up against a large corporation's legal team with a whole legal department and unlimited resources is genuinely intimidating. But here's what most people don't realize about employment law specifically. Many employment attorneys work on a contingency basis or offer free initial consultations. That means the financial barrier to at least finding out where you stand is much lower than people assume. And more importantly, corporations do not want litigation, especially in the context of a mass layoff where multiple employees might have similar claims. A lawsuit, or even the credible threat of a lawsuit, changes the calculus for a company almost immediately. They have reputational risk, discovery risk, and the possibility of class action exposure if many employees were treated the same way. This person's situation involves potential WARN Act violations, a questionable non-compete that appears to lack adequate consideration, and an abrupt termination after 21 years of service. That's not a weak hand. That's actually a fairly strong set of facts to bring to an employment attorney. Has anyone successfully challenged this kind of situation? Yes, regularly. Non-compete agreements get invalidated in court and in pre-litigation negotiations all the time, particularly in states like Illinois that have moved to strengthen worker protections. Companies frequently agree to narrow or waive non-compete restrictions when faced with a credible legal challenge, especially when the employee was laid off and received no severance. Because a court is going to look at that arrangement and ask, what exactly did this employee receive in exchange for giving up 6 months of their right to work in their chosen field? And if the answer is nothing, that's a problem for the company. So what should someone in this exact situation do? First, document everything immediately. Save every piece of correspondence, every email, every document related to the layoff and the non-compete. Do not delete anything. Second, pull out any employment agreements, offer letters, non-compete documents, or employee handbook materials you signed. Review what you actually agreed to and when you signed it. Third, contact an employment attorney in Illinois, ideally one who specializes in employment contracts and non-compete law, as soon as possible. The consultation itself will cost you nothing in most cases, and it will tell you within a short conversation whether you have actionable claims. Fourth, file for unemployment benefits immediately if you haven't already. The non-compete does not affect your right to collect unemployment. Those are separate legal tracks. Fifth, look into whether your layoff qualifies under the WARN Act. If you were part of a mass layoff and received no advance notice, that is a separate and potentially significant legal claim. The broader lesson here is one that applies to every single person watching this, whether you've been with your employer for 2 years or 20. Non-compete agreements are not automatically enforceable just because you signed them. Courts look at context. They look at fairness. They look at whether you received anything of value in exchange. And when a company lays you off without warning, without severance, and then tries to restrict you from working in your field, the law, at least in Illinois, has things to say about that. 21 years of loyalty does not legally guarantee you severance, but it does mean you have a documented history with the company, likely a strong performance record, and the standing to make a company very uncomfortable if they try to enforce a restriction that courts may well find unenforceable anyway. You are not as powerless as that 15-minute meeting was designed to make you feel. If this has happened to you, a sudden layoff, a non-compete with no severance attached, or any combination of what we talked about today, do not just accept it and move on. Talk to an employment attorney. Understand your rights before you decide anything, and share this video with anyone you know who's going through a job loss right now, because this information can make a real difference in how their situation unfolds. If you want more breakdowns of real legal situations like this one, situations that affect real working people, subscribe to this channel. We cover these stories every week, and the next one might be exactly what someone in your life needs to hear.